Hello, everyone. This is Elizabeth Samples. I'm an attorney in Husch Blackwell's education group. Good afternoon or morning, depending on your location. We're very excited to give today's presentation on new immigration policies that affect colleges and universities and their international students. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'd like to take a minute to highlight a few of these key icons for you. If you have any questions during the webcast, please submit your questions via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or if we run out of time, it will be answered later via email. We appreciate audience participation and encourage you to submit questions as you have them. There's also an icon to assist with your viewing preferences. Please note that you can expand your slide area by clicking on the maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulty, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the resource list icon that looks like a folder at the bottom of your screen. As for CLEs, this program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin CLE credits. To report your hours in Illinois, Kansas, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. You'll need your bar numbers to submit. Finally, a recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with your certificate of attendance. So joining me today is Kelly Stout. Kelly focuses her practice on business immigration law, representing a wide range of employers in obtaining and maintaining employment authorization for foreign national employees on a temporary and permanent basis. She represents employers across various industries, including technology, engineering, manufacturing, healthcare, and of course, education. So we're very grateful to have Kelly here with us today. So first, just want to give an overview of today's topics that we'll be covering. Of course, we'll be giving an update on the Deferred Action for Childhood Arrivals, or DACA program. As you know, this has recently been rescinded, and so there's some question about what's to come, and so we'll be talking about DACA. We'll also be talking about other immigration policy changes and some proposed legislation that affects your international students. We'll also be talking about Immigration and Customs Enforcement Actions, or ICE actions, talk a bit about the risks for your institution and how to respond. We'll be talking about sanctuary policies. Some of you may have already implemented sanctuary policies at your schools. Others of you may be considering them. And so wherever you are in that process, we're going to provide some sort of background on what they are and what's enforceable and some best practices. And then finally, we'll talk about admission policies for international students. So now I'm going to turn it over to Kelly.
Hello, everyone. We are going to start today talking about DACA. We had thought this was going to be the hot topic of this presentation, and then Sunday came, and we received news of another travel ban. So for those of you who are anxiously awaiting information about this new travel ban, you can add that to the list. We'll get to that here in a little bit. We'll talk about that as well. But we're going to start today talking about DACA, the Deferred Action for Childhood Arrivals program. As most of you know, this program was suspended or done away with by the Trump administration. But I do want to start by giving a little bit of background about DACA. This might be a reminder or a refresher for many of you, but I think it's important to see what DACA is before we talk about sort of its future. DACA is a program that doesn't grant any sort of immigration status. It was implemented in 2012 by executive order from the Obama administration. And all it offers is protection from deportation. It's not a visa status. It's not a visa at all. It's just sort of deferred action. You can stay here. You let us know you're in the country, you are not documented, and the government won't deport you. It was available to undocumented immigrants, mostly children who came to the United States before age 16, who had never left the United States or had left only for brief periods of time, either graduated high school or enrolled in school, or maybe they were completed or working on a GED program, or they might have been honorably discharged from the Coast Guard and military. DACA grantees had to prove they didn't have a criminal record, which meant that they weren't convicted of a felony, significant misdemeanor, which is DUIs mostly, or 3 or more insignificant misdemeanors. And every 2 years they had to reapply for the DACA program. Many DACA grantees at this point have enrolled in post-secondary education. They might be at your schools. You may not know that they are DACA grantees because they have a Social Security number and maybe you just don't know who they are. But they are students. A lot of them are students in colleges and universities now. So what happened? So DACA was rescinded on September 5th, 2017 by the Trump administration. And after this date, there was no new DACA applications that are being accepted by the government. Those who have DACA authorization now, whose work authorization, so as part of DACA, a DACA grantee gets a Social Security number, they get work authorization, like a work card, and those who have work cards that expire before March 6, 2018 are allowed a one-time renewal if they file that application before October 5th, which is coming right up around the corner next week. But for those who expire March 7th, 2018, as of that date, they are no longer a DACA grantee, and they no longer have this authorization in the United States. The future of the program is sort of uncertain now. The idea was we're going to rescind DACA and sort of that the Obama administration didn't necessarily have the authority to do this, so we're going to say it's time for Congress to act. That's the idea of it. And so we're kind of waiting to see if Congress actually decides to take action on DACA. Obviously, they have a very long to-do list, so we'll see where DACA ends up sort of on the priority list in the next, before March 6th. It's possible, and I think through one of the president's tweets, we saw that he's indicated or sort of hinted that if Congress doesn't take action, he will. And so we're just kind of seeing the president could issue a new executive order about DACA. That could happen as well, but right now we are really in sort of an uncertain period for DACA students. So what happens to DACA students? So those students who are enrolled in your institution, what does this mean for them? Well, once their DACA authorization ends, so does their permission to be inside the United States. So at the point that their DACA authorization ends, they no longer have permission to be here, and they are undocumented immigrants. DACA students can be deported at that point once they no longer have authorization. They could be placed in removal proceedings. This is immigration court. They could, at any point in time, once their authorization runs out. U.S. Citizenship and Immigration Services, USCIS, is in possession of the DACA students' information. So whenever they apply for DACA, they have given their address history. A lot of times they submit where they work, where they go to school, all of that information. And they're required to update their physical and mailing address if that ever changes. So the government and USCIS knows where they live. USCIS can certainly release that information to Immigration and Customs Enforcement, or ICE, which is the enforcement arm of all of the immigration agencies under the Department of Homeland Security. So certainly that information would be easy to find a DACA student and put them in deportation proceedings or immigration court. So we don't know what will happen. I think there's been some talk about whether or not ICE is going to put these DACA students on top of their priority list. But students really should be prepared about what's going to happen next. be prepared for what happens with their work authorization runs out. And a lot of colleges and universities are asking me, well, what can we do? What can we do? And there's not a whole lot. I mean, this is just sort of what's going to happen with the program. And we'll talk about sanctuary policies because that sort of ties into this, and Elizabeth's going to talk about that here in a little bit. But really, for DACA students, they probably need to talk with Immigration Counsel to understand their options, understand what the next steps are, but certainly that's sort of on them as individuals. Okay, let's get into some of the other immigration policy changes that are happening and how your international students might be affected. ICE, which is I just mentioned, is Immigration and Customs Enforcement, and this is probably the agency that you see in the news quite often. They are the agency that's going out there and detaining and prosecuting and removing individuals from the United States. In immigration court, the ICE attorneys act as the prosecutors in immigration courts. So really, when you're looking at immigration, there's a wide range of agencies, but ICE is really the enforcement arm. So when you see news articles about somebody being arrested by ICE, that's why they're the agency that goes out and does that. But ICE sort of has this broader role too. So your organization might run into ICE because ICE runs the F1 and J1 and M1 student exchange visitor program. So ICE has sort of other duties as well. They also conduct Form I-9 audits, and they penalize employers for noncompliance. So ICE really has a lot to do. They are stretched thin, and certainly are put on many hats throughout the immigration world. When President Trump took office, he signed an executive order called Border Security and Immigration Enforcement Improvements. This was sort of how are we going to use ICE, how are they going to up their enforcement power to really enforce the immigration laws in the United States. About a month after that, the Department of Homeland Security released 2 memoranda which were sort of detailed how these measures are going to, the exact measures, what is ICE actually going to do in the United States. One of those memos dealt with border security. How is ICE going to enforce immigration laws at the border? What are they going to do? And the second memo really talks about ICE enforcement changes inside the United States. And both of them together sort of give us a hint about what's going to happen in the future and what has been happening in the last few months since these memos were released. The one that you probably are it's a lot to talk about ICE. The one that you'll probably hear about most often and that will affect you as a university or college or institution of higher education is the Department of Homeland Security memo on interior enforcement. And what this memo details is the hiring of an additional 10,000 ICE agents, which is a significant number. That hasn't happened yet, but certainly could happen as we work on budgets and they rearrange their own internal budgets. But certainly that's a significant increase in ICE agents throughout the country. Also details the increased use of local law enforcement to enforce immigration laws. This is a program that's already been established. It's called the 287G program, where certain local law enforcement would partner with federal immigration agents, ICE agents, to help enforce immigration laws locally. So the Department of Homeland Security memo sort of details that they want to increase the use of this program, have more partnerships between ICE agents and local law enforcement, basically more feet on the ground enforcing immigration laws. The memo also expands the categories of people who qualify for removal without judicial process. This just means expedited removal. So in other words, if somebody is undocumented and ICE arrests them, that usually the process is that those individuals end up in immigration court to see whether or not those individuals are removable or deportable from the United States. Expedited removal means that once ICE arrests you, they can deport you. And essentially this memo details sort of an expanded use of expedited removal. It also expands the categories of individuals targeted for ICE enforcement. In other words, what used to be sort of a priority list in the Obama administration, well, we only have so many ICE resources, we're going to prioritize locating and arresting those undocumented immigrants who have committed felonies or other serious crimes, and everybody else is sort of on the lower end of that priority list. Well, when this memo basically says any undocumented immigrant is subject to ICE enforcement and may be put in removal proceedings. So, as ICE's resources increase, that means that their enforcement power and who they target can be expanded. And that's really just a high-level view of this. I mean, certainly there's a lot more details, but you can kind of get the idea of, okay, we're going to up the resources that ICE has. We're going to up the enforcement measures throughout the United States, both interiorly and at the border. So what does this really mean? You're going to see an increased use of ICE enforcement measures to detain undocumented immigrants. Whether we've seen that in the past few months is sort of up for debate. It's certainly in the news a lot more, but it's hard to tell. It's hard to tell just after a few months if it's been prolific. What I have noticed is that ICE has been reacting to tips a lot more. So certainly if somebody calls in, and this usually happens in an employment context, where somebody calls in and says, oh, I know so-and-so is an undocumented immigrant, ICE is very responsive to that. But as far as a jump in the number of raids or things like that, I haven't seen something very significant yet, but certainly we're only in September. It also creates some anxiety and confusion within the international student community. Certainly all these enforcement policies, things coming out about immigration in the news and from the Trump administration have sort of scared international students a little bit. So we've seen a decline in international student interest and enrollment in some institutions of higher education. And it creates a lot of confusion. Who is ICE really prioritizing? What does this mean for my family? Things like that. But certainly, again, we are only in just basically the first, several months of the enforcement or the implementation of these memos. So some other policy changes that we've seen, this deals more on the visa side, so how individuals obtain a visa. Extreme vetting procedures. This was part of the executive order, and we've seen it in a couple of other things coming out through the Trump administration and those specific agencies. We see this in the travel ban. And what this really means is when they talk about implementing extreme vetting or enhanced vetting procedures, what it really means is that there's going to be more delays at in obtaining an appointment for a visa at a U.S. consulate. So if you have a student leave, international students, they've got to they have to obtain a visa outside of the United States and come back in. It's just not something that they can do in a week. They really need to be planning for their visa appointment well in advance. And that goes for any of your, this is meant to talk about international students, but to the extent you have an employees who are on visas, it's the same concept applies. It's just not something you can do in a week these days. It's going to take more time. Certain individuals are going to have to fill out additional forms. It's going to take longer. I have individuals who are at the border their cell phones are getting searched. So there's just some more vetting procedures that are going on. H-1B visa reform, this doesn't affect international students directly. It does affect some of your faculty or staff who might be on an H-1B visa. But for F1 students, usually the path that you have for your international students is they come here on an F1 visa, they go to school, they graduate, then they go into a period of 1 year or sometimes 3 years of employment eligibility through their F1 student visa. And after that point, they look for employer sponsorship to continue to work in the United States, and they do that through an H-1B visa. However, the H-1B visa is sort of under increased scrutiny by U.S. Citizenship and Immigration Service, the agency that sort of adjudicates H-1B petitions. And as a result, H-1Bs are a little bit harder to get these days. This doesn't affect how many H-1B visas are available. Those of you who are familiar with the program know that there is a limit, a numerical limit on the number of H-1B visas available. That's still the same. That requires congressional action to change. But certainly we've been seeing a lot more requests for evidence on these H-1B visa petitions. And certainly it might affect those international students who are sort of relying on this typical path as they look to stay in the United States. So I wanted to at least mention that issue as well. Okay, I think you've heard me talking enough. Let's take a quick break for a poll question. And we're going to start talking about the travel ban and switch gears a little bit. And I'm interested to know if your schools have been affected by the earlier versions of the travel ban. You know, you may not know. Certainly some students, you just don't ever report that information, but you might have had some international students from one of the affected countries who either weren't able to obtain a visa or were scared about traveling outside of the United States, something like that. Okay, it looks like we're pretty split. About a third of you said yes, a third of you said no, and just over 40% of you, I guess, said I don't know, and that's okay. We're going to talk about it because we are now at Travel Ban 3.0, which came down on Sunday, September 24th, 2017. So as many of you know, there has been a few iterations of the travel ban. It first came down and it sort of caused all this confusion. What does it mean? What does it mean? And then in March we saw a revised travel ban that sort of clarified how the travel ban was supposed to be implemented. And as I'm sure many of you know, this has been tied up in litigation and now sitting with the Supreme Court. The travel ban, previous versions of the travel ban are sitting with the Supreme Court, who's basically said, at this point, now that we have a new travel ban, we're going to let the parties brief this issue again, because at this point the Supreme Court's hearing on the earlier versions of the travel ban might be moot, or just there's no reason to rule on the earlier versions of the travel ban now that we have a new one out there. So the new one, which was issued on Sunday, is called Enhancing Vetting Capabilities and Processes for Detecting Attempted Entry into the United States by Terrorists or Other Public Safety Threats. Apparently none of the executive orders can have short titles, so we get something that's very, very long. But this executive order calls for an indefinite travel ban on the entry into the United States for individuals from designated countries. And we'll talk about those here on the next slide, but I won't go through them individually. But basically, it's sort of like the other prior version or the revised version of the travel ban, except for it carves out specific classes of people who are ineligible for certain types of visas. And adds a couple countries to the list. Sudan dropped off the list. And sort of the same, some of the same rules apply. So the travel ban doesn't affect lawful permanent residents. It doesn't affect dual nationals. So dual nationals would be somebody who has citizenship in one of the affected countries, but also has citizenship in a non-affected country. So, for example, it might be somebody with citizenship in Venezuela and somebody who has citizenship in Canada. Or it could, and foreign nationals who are in the United States on October 18th of 2017, which is the effective date. Here is a sort of a list. I'm sorry that the font is so small, but here is who is affected as of right now on the travel ban. I think somebody had a question about Venezuela. I mentioned it, but really Venezuela is only going to affect certain government officials and their family members who are coming in on tourist visas, and any other individual is going to be subject to additional security measures, and what those are, I'm not quite sure yet. But again, you'll see there's a couple additions on this list, and some of the same countries, at least 5 of them, I think, are the same. When I talk about immigrant visas on the slide, immigrant visas or immigrants are those individuals who are coming to the United States as permanent residents or green card holders. Non-immigrants are those like your student visa holders who are coming to the United States temporarily. So if they're a student, they're coming here on maybe an F1 visa to go to school, and then they intend to go back to the United States. So many of these only affect those individuals coming here on immigrant visas, so seeking permanent residence or a green card when they come to the United States, and then some tourist visas as well. And this is subject to change. I mean, the idea behind this Travel Ban 3.0 is that the administration could revise it. They could add countries. They could take countries off the list as they see fit, and look at our security measures and what information these countries are giving to the United States. So as far as your students, what do they need to know? They need to know when it goes into effect. Even those prospective students from designated countries who aren't part of one of those classes of people who are prohibited really should be contacting Immigration Counsel to talk about the future of their immigration status, to talk through applying for a visa. They might be eligible for the visa. They might not be prohibited from traveling by the travel ban, but they are from that affected country. It can't hurt to talk to an Immigration Counsel for those students to get in contact with Immigration Counsel, because they still might have some trouble obtaining a visa. Those prospective students or your current students from those designated countries might not be able to enter the United States next semester if they were planning on traveling at the semester break, or they might have difficulty obtaining a student visa if they are part of one of those classes of people. So this is something to keep your eye on. Again, the list is a little bit more restricted. It's not going to affect as many student visa holders as before because they've carved out those exceptions. They're saying it's only applying to those seeking a green card and tourist visas, but certainly any student who's from one of those affected countries might have some trouble at the consulate and should really be talking to see what their future might look like and what traveling would entail. Okay, so I want to switch gears here before I turn this over to Elizabeth to talk about ICE enforcement actions. This is, we talked a little bit about ICE and the change in ICE policies, and then I wanted to get in a few minutes about the travel ban. But we really want to also give you some information about preparing for ICE enforcement actions, because this has been sort of a topic on everyone's mind as well, because you've seen it in the news. A lot of universities and colleges are responding to different immigration policy changes that have come out by this administration. And we want to talk about what's actually going on and how to be prepared. So, ICE can come and conduct enforcement actions really anywhere. They do this through subpoenas, search warrants, arrest warrants. They could be coming to look for documents or information about a student. They could be looking to arrest a student, foreign national or undocumented student, I should say. They could be looking for an employee. For example, a faculty member who might have been on a visa or or a staff member or somebody else might be using false documents to work. So there are a lot of things that ICE could be looking for, but in general you can put these sort of into two categories, as documents or information or arrest. If it's documents, usually ICE is going to have to present that subpoena or search warrant. If it's to arrest a student, usually they're going to present an arrest warrant, and if it's they may also need that search warrant as well. There is a sensitive locations memo from 2011, and this basically sort of restricts ICE enforcement power on campus to an extent. This memo from 2011 is still in existence, and it basically says colleges and universities are sensitive locations, meaning that they require supervisory approval before ICE can conduct an enforcement action in that location. It covers arrests, interviewing people in that location, searching that location, surveilling that location. There's an exception for exigent circumstances in that memo, and for right now that memo is still in effect, and we've been told that they are still following the procedures of that memo, but it certainly could be rescinded at any point in time. The interesting thing about ICE enforcement power on campus and ICE's search for information or documents is that FERPA sort of comes in conflict with ICE's enforcement power. As most of you probably know, FERPA protects the privacy of student information for schools that receive funding by the Department of Education, and that includes information about immigration status. FERPA, just to put a card out here, does not protect international students, so students who are in F1, M1, or J1 immigration status. They're sort of a separate and distinct from every other student. There is an exception to the FERPA privacy protections and directory information, student's name, phone number, address, attendance, full or part-time status are sort of examples of that. And there's also an exception for compliance with a judicial order or lawfully issued subpoena, which is sometimes what ICE shows up with when they are conducting an enforcement action at an organization. There is a law, 8 U.S.C. 1373, which I think is good to mention here as well because it sort of also conflicts with FERPA. And that law basically says that so any federal, state, or local government entity or official, so those of you who are public or state-funded universities or colleges, those officials or personnel cannot prohibit or in any way restrict any government entity or official from sending to or receiving from the Immigration and Naturalization Service information regarding citizenship or immigration status, lawful or unlawful of any individual. Essentially, this is seems to be saying that you, if you're a public university, cannot prohibit your employees who are from releasing information about someone's citizenship or immigration status to the appropriate immigration agencies. There is some question here about how FERPA and that law sort of come into play, and I have to put a question mark there because we don't know yet. We haven't, certainly I think if we see more ICE enforcement at colleges and universities, then we're really going to see both of these laws sort of butt heads a little bit. But for right now, they haven't really been challenged. We haven't seen a lot of ICE enforcement on college campuses, or at least we haven't seen a proliferation of it, which would sort of mandate any sort of court actions to determine, what would happen. Does FERPA supersede the, this other 8 U.S.C. 1373, or how do they work together? And we just don't know yet. So I want to leave you with some best practices for an ICE visit to campus. And, the first thing that I'm telling universities, that I tell the employers that I work with and other organizations that I work with, is to designate somebody within your organization to handle visits from ICE. It might be that it might be several people. It might be if they want to arrest somebody, they need to check in with campus security. If they're looking for a student, they need to talk to X person. If they're looking for an employee, they need to talk to X person or Y person. So have somebody, at least one person designated, who knows best practices for interacting with ICE agents. And again, ICE agents might just be visiting your organization just about the J1, F1, or M1 student program if you sponsor international students. So it's good to have understand why ICE might be there and have somebody who knows how to handle those visits. So you're not just having some somebody on the front lines who gets freaked out and just says, oh, here, you're an official from the government, let me hand you all of this information, just so that anybody who comes into contact with them knows who to call. The second thing, which I've listed first because I think it's incredibly important, is to notify and consult with counsel, somebody who's experienced in dealing with ICE visits and who can direct your organization or your college or university how to handle what your rights are as a school and what you should and shouldn't do and how you should interact with the ICE officer. Also, it's helpful to develop some procedures to guide those who might first encounter an ICE officer, just some simple things. And really those procedures can be as simple as the first thing you need to do is ask for the officer's name. Ask for their business information, a business card and their contact information. Ask the purpose of their visit. Those first few steps are something that you would be surprised how many people forget to ask when they first encounter an ICE officer. And also those procedures should detail that it's important to accompany the ICE officer at all times while they're on campus and to make a copy of any documents the ICE officer takes. So if the ICE officer is taking documents to make a copy. Those procedures should also detail that the person should ask for the search warrant, subpoena, or arrest warrant, whatever might be appropriate in the circumstance. I haven't seen this in the university context yet, but I've certainly seen it in some other organizations where ICE officer will show up without a warrant and they'll claim some warrant exception, and the organization has pushed back a little bit and said, I really would like to, I can release this information, but do you have a warrant for it? They've pushed back, and the ICE officer will come back with that warrant a few hours later, or the appropriate subpoena or whatever they need to get that information. So they'll usually go get it, and sometimes it's a good idea to push back. Sometimes it might not necessarily be the right thing to do, but that's why it's important to consult with experienced counsel, to have that designated person within your organization to handle those visits. The final thing I want to talk about with respect to ICE enforcement measures is public versus private areas. ICE can't enter a private area of an organization without a search warrant or your consent or some other exigent circumstances, exception to the warrant requirement. For those of you attorneys, we're going back to constitutional law. But there are public areas where ICE officers can just walk around. I mean, any public areas where you would normally permit the public to enter. So that might be your campus quad or restaurant dining area, parking lot, waiting area. Parts of campus where the public is, generally allowed to visit. Those ICE officers can just be walking around. Those ICE officers cannot just go up to somebody and arrest them without, a warrant or some other basis for arrest, though. There is a distinction there. So when we talk about sanctuary policies, and I'll hand this off to Elizabeth to go into that distinction will matter in those sanctuary policies.
All right, thank you so much, Kelly. So now, as Kelly mentioned, we'll talk about sanctuary policies. Again, recognizing that many of you may be at sort of different points in considering whether or not a sanctuary policy is appropriate for your institution. So we'll start at kind of an overview of what they are, and then some considerations for you as you think about sanctuary policies. So first, of course, in light of increased immigration enforcement, schools have been considering how far they can legally go to protect their students using sanctuary or safe zone policies. So as Kelly discussed, ICE and CBP do have a longstanding policy not to carry out immigration enforcement in sensitive locations, including schools. But given recent changes, some are concerned about reliance on these memos, and so think that additional sort of action is necessary, and are considering these sanctuary policies. Some schools are, of course, grappling with conflicting viewpoints from community members about whether sanctuary policies are appropriate. And, of course, there are legal implications related to the intersection of federal immigration efforts, state and local laws, and other administrative reporting obligations that really need to be considered when thinking about sanctuary policies. So foundationally, schools are considering these policies to insulate their international students, typically their undocumented students, from ICE enforcement. So these policies really begin with a belief that feeling safe at school and in the educational environment is critically important for one's access to the education. Also, institutions worry about sort of a climate of fear that may be related to immigration enforcement that may be impacting not only the students directly affected, but the community in general. And so that's really what's kind of driving institutions to consider these policies. So the schools, that have considered them, believe that the learning environment could be disrupted by ICE agents or other immigration enforcement on campuses, and so are seeking to sort of create policies in response to that. So aside from more sort of mission-related reasons, schools also adopt these policies for legal reasons. So on the one hand, there are potentially equal protection and Fourth Amendment principles at issue. But when grappling with this, schools also have to consider other laws and making sure that their sanctuary policies aren't running afoul of other laws. So institutions have to be careful that they're not making promises for protections that would, again, break the law in other areas or conflict with their administrative obligations. So typically these will require certain procedures for entering parts of the campus. As Kelly mentioned, typically the parts of campus that are considered private, so requiring law enforcement officials seeking to enter campus to check in with campus police or with another office. And we'll sort of go through that a bit more when we look at some examples from sanctuary policies. It's critically important, of course, that individuals who are going to encounter officials, as Kelly mentioned, that they're trained regarding the implementation of the sanctuary policies. So, for example, if there's a provision in the sanctuary policy that relates to the gathering and sharing of student information, it's critically important that the staff be trained on the policy so that they're aware of their own obligations. This also sort of ties back into what Kelly discussed related to FERPA. So notice to staff and to students is critically important with the overlap of FERPA and other obligations to potentially turn information over to immigration enforcement entities. So it's really important to provide the notice to students of, what is directory information? What directory information do we have that may be that may tie into your immigration or citizenship status, and making sure that students are aware of opt-out provisions related to FERPA. So here we have some sample sanctuary policy statements. So there in the first example, you'll see, of course, many of these policies begin with a statement about the overarching purpose of the policy. So ABC University will do what it can to provide the safety and success of undocumented students. As discussed, schools should be careful about the promises they're making here, and so this mission and purpose section, really needs to be carefully crafted. Again, another common element, of course, is restricting immigration agents' access to campus where appropriate. So they often include a process for requesting access to campus, specifying, how the request should be made, to whom the request should be made, and generally have a process for reviewing and approving ICE requests for information or, other access to campus. So it may state, for example, that requests for information will initially be denied by whatever staff person is first approached, and they'll be forwarded to a specific office on campus, so the president's office or general counsel's office, who will then be able to, review the situation. This may include, review of the warrant that's provided by ICE. Depending on the particulars of the warrant, the school may be left, of course, with no choice but to turn over the student information, but the sanctuary policy may have, implemented, again, a process to ensure, that the college goes through that. Next, the policies often specify and limit campus police involvement with enforcement activities. Sometimes these policies, begin with a statement that campus police don't have the authority to enforce federal immigration law, and declare that they won't use their resources to participate in immigration enforcement efforts. This is sort of a similar theory that applies to other kind of anti-entanglement laws with city or county ordinances and police offices there that prohibit those police from using resources to assist in the enforcement of federal immigration law. This can be, of course, a highly technical and legal issue with respect to the intersection of the two, and so this is, of course, an important area for institutions to, consult with counsel and also to consult MOUs that they may have in existence with local law enforcement to make sure that there's no conflict between what they're saying in the sanctuary policy and any MOUs. Finally, another common element to sanctuary policies is the commitment to providing resources and information for immigrant students and their families. So schools may be creating special resource centers or other, on-site spaces for students and families. For example, undocumented student centers or dream resource centers where individuals can seek counsel. In all cases, again, just to reiterate, it's important to consult, both internally and with counsel before enacting these policies to ensure that there's no conflict. So here, when it relates to best practices, again, first and foremost, ensuring that the school is complying with other state and federal laws when implementing sanctuary policies is critical. The policy should be, carefully vetted with stakeholders and with counsel. Again, there's no federal law that mandates that local colleges and universities assist in ICE enforcement, but you do have to consider the implications of 8 U.S.C. 1373, as Kelly mentioned, which states that you can't prohibit communication with information with federal immigration authorities. This issue of sanctuary campuses and particularly sanctuary cities is proving to be an evolving issue as the administration and states attempt to enact laws related to sanctuary cities, and these decisions can shed some light for schools' limitations as they're looking at these policies. So President Trump issued an executive order that sought to defund sanctuary cities, but the Ninth Circuit did issue a nationwide injunction when that was challenged in California. A bill in Texas has also been working its way through the courts. Similarly, this bill is targeted at sanctuary cities and seeks to stop them from opting out of federal immigration efforts. Initially, a lower court had ruled that most of the law's provisions attempting to bar these sanctuary cities were unconstitutional. Just yesterday, however, a Fifth Circuit panel ruled that the state can enforce some sections of the law. So, for example, now one enforceable section says that local authorities can't prohibit their employees from assisting a federal immigration officer, and this may have some implication for campus police, on our public institutions. So, schools that are located in sanctuary cities may have an easier time developing and implementing sanctuary policies, within their own community, but clearly, as the Texas bill demonstrates, schools have to be careful that they're really staying current with legislative and legal changes in this area. Another example of where schools need to carefully examine their sanctuary policies is with respect to the Student and Exchange Visitor Program, SEVP, for your students on student visas. When you're certified by SEVP, you have an obligation to comply with mandatory data reporting, as well as giving enforcement agency access to campus in order to maintain your certification to have these students on student visas. So schools have this reporting obligation to SEVP, and these obligations remain, despite your efforts to, potentially have a sanctuary policy. And so, this highlights a point we discussed earlier. You really have to be careful what you're promising in your sanctuary policy, because you will still have, obligations to respond and turn over certain information. Finally, federal law prohibits harboring someone who is a known undocumented individual. And so it's one thing, for a college or university to require process steps for ICE coming onto campus, or to train campus police not to inquire about immigration status of its students. Of course, it's another to knowingly harbor or shield an undocumented student from enforcement. So schools who do this, could open themselves up to liability and need to be careful there. So in summary, as with all policies, you need to consider the purpose for implementing a sanctuary policy and clearly define the scope and the protections within it. We don't want to set up unreasonable expectations for what the policy actually does. And we want to make sure that it's not, running afoul of any other obligations. And then it's a matter of proper communication and notice to affected individuals about what the policy actually does and what its protections are and what its requirements are. Okay, so finally, we're going to conclude by just talking a bit about admissions policies for international students at a high level. Obviously, there are many technical details regarding the processing of admission applications for your international and non-citizen students. We're going to focus on making policy determinations, about these admissions issues, and then adhering to the policies. And additionally, we'll discuss some non-discrimination considerations. So here, just two quick poll questions. First, does your school ask for citizenship or immigration status on your admission application?
And you might not even know, and that's okay. Click I don't know. But it's kind of interesting to see who does and who doesn't, and how many of you, I guess. We don't know who, but how many.
Okay, so it looks like close to 40% of you responded that you do ask for citizenship or immigration status on your admission application. Close to 20% of you do not. And again, as Kelly said, it's just interesting to sort of see whether the schools are asking for this type of information. We have a related question here, which is if you do ask for citizenship or immigration status information, do you then require proof or documentation of the citizenship or immigration status as a part of the application process? We'll give you a minute here for the answers to come in. So keeping in mind that about 30 to 40% of you did ask for information, of that group, we'll let a few more answers come in here. It looks like about 40% of you are not then requiring proof of that citizenship or immigration status, while about 20% of you are. And so, we do see that, right, that some institutions sort of adopt more of a kind of honor system where the proof of that documentation is not required. There, are some considerations there because, when you do ask for this proof, that does, of course, create additional administrative burden, for you and your staff. Having to review the documentation, maintaining the documentation. And so those are, considerations to keep in mind when thinking about, asking for these types of questions. Also, of course, want to make sure that you're doing so on kind of an equal basis to avoid, any sort of national origin, discrimination complaints related to the request for proof. So at a high level, admissions determinations about undocumented students particularly begins with, as we just discussed in the poll questions, what questions are we going to ask and what type of documentation are we going to require? So there's no federal law prohibiting schools from admitting undocumented students, but schools, can of course create policies dictating what type of information will be required. And also create policies that admit students depending on different types of immigration status. So higher education differs in an important way from K-12 in this context. Plyer versus Doe established the right of all children to a free public K-12 education regardless of immigration status. But non-citizen students may be able to make equal protection arguments and possibly other discrimination claims in the higher education context. So schools want to be really clear, about their admissions policies to be able to, defend these practices and decisions. Also, there are, of course, financial implications for undocumented students. Even if a school has an admissions policy that admits the students or doesn't ask in the first place, undocumented students are not entitled to federal financial aid. And we'll conclude with, just a brief overview of some state laws that relate to funding for DACA students. So obviously, many issues come to mind when we refer to discrimination in admissions. Non-discrimination requirements apply to various protected categories, but today we're just focusing on the specific aspect of admissions that relate to international and non-citizen students. So again, schools have to make admissions policy determinations about different categories of students. So when we refer to international students here, we're referring to students who would be participating in a student visa program, whereas a non-citizen student would generally be someone who is residing in the United States who is not documented. So when making these determinations, schools have to keep due process and equal protection considerations in mind. Non-citizen residents are entitled to the protection of due process and equal protection clauses. For this reason, again, council should be involved in making certain admissions policy determinations. Additionally, schools who receive federal financial assistance, even if that's just in the form of financial aid to your students, those schools are subject to Title VI, which prohibits discrimination on the basis of race, color, or national origin. Discrimination based on national origin is different than discrimination based on citizenship or immigration status, but it can be a fine line. So, for example, it's certainly permissible to ask questions about immigration status, but you need to be careful that you're, implementing the policy so as not to exclude students based on either their national origin. So schools should make clear determinations about what groups of students they're going to admit based on immigration status. And then, as with all other admissions decisions, document it and document the reasons, for those admissions decisions. The benefit of an admissions policy that's open to all students, regardless of immigration status, is, of course, that it increases, the eligibility, and creates for a larger pool of applicants. But some schools have concerns about admitting undocumented students because of potential issues for their future employment and also the risk of deportation, during their studies. So for these reasons, some schools adopt policies that open up application to U.S. citizens, lawful permanent residents, or students with valid immigration status, but exclude undocumented citizens. So again, it's really just important to make sure that the documentation related to these decisions is clear. So for example, if your institution asks questions about citizenship or immigration status and a student provides that information but then fails to provide supporting documentation as required by your policy, and that student is then not admitted, you'd want to make it clear that student was not admitted for failing to comply with basically the policies and procedures of your admissions process, and not because of his or her citizenship. Finally, as sort of an overview here of state laws related to funding, for undocumented students. So as many of you are aware, states have varied in their responses to students and funding issues specifically. So 20 states offer in-state tuition to unauthorized immigrant students. Some of this is by legislative action, and some is by the state university systems themselves. Other states, like Kansas, there on the slide, have enacted laws to allow in-state tuition benefits if certain criteria are met. So one of those criteria would be a commitment to attempting to obtain legal status, as soon as possible. Several other states, including Missouri, bar unauthorized immigrant students from in-state tuition benefits. So here again, understanding state law is important when considering the admission of undocumented or DACA students. Okay, so that concludes our presentation. Thank you again for joining us today. We hope the information was helpful for you and your organization. Again, if there are any additional questions, we're happy to answer them offline. If you haven't already, please click the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. As a reminder, the program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin CLE. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link will be emailed to you. The recording will be available for 2 weeks. Please be sure to join us for our next webinar on October 19th on requesting criminal histories on campus. This concludes our webinar. Thank you.